Veuillez vous asseoir.
The sitting is open.
L'audience est
The court meets this afternoon to hear the Gambia's second round of oral argument. I invite Mr. Paul Reichler to address the court. You have the floor.
Vous avez la parole, monsieur.
Madam President, members of the court, I am again honored to appear before you in these proceedings. I will present the Gambia's response to the arguments you heard from Myanmar on Friday, followed by the agent who will deliver the Gambia's formal submissions. My remarks can be brief because, frankly speaking, there is not much to respond to. Although Myanmar took up the entire 90 minutes allotted to it by the court, it did little more than repeat the same arguments it made in the first round, to which the Gambia fully responded last Wednesday. I begin with preliminary objection number 1. Madam President, one of the most moving moments I have ever experienced in this great hall of justice since my first argument here in 1984 occurred on 12 December 2019 as I was about to begin the Gambia's second round in the oral hearings on provisional measures. As I was waiting at the podium for the hallowed cry, La Cour, a member of our team tapped me on the shoulder and insisted on showing me a video that had just arrived on his mobile phone. It was of a remarkable event that occurred that very morning in the overcrowded refugee camps of Bangladesh. Thousands upon thousands of Rohingya had gathered in an open field. They were chanting rhythmically, "Gambia, Gambia, Gambia." Madam President, the Rohingya are continuing to follow this case very closely, and they have no doubt who the applicant is or about which party is seeking to hold Myanmar accountable for its genocidal acts against them. And neither should the members of this court. It is Gambia and no one else. The video is publicly available, and you can find the link in a footnote to this speech. It is entirely irresponsible and offensive for Myanmar to continue to argue that someone other than the Gambia is the real applicant here. On Friday, Mr. Staker acknowledged what the evidence already indisputably shows, that the decision to bring this case was made by the cabinet of the Gambia in July 2019 upon the proposal of the Gambia's Attorney General. It was announced publicly by the Vice President of the Gambia before the UN General Assembly in September 2019. These were sovereign acts by a sovereign state taken at the highest level after the most careful consideration. Myanmar would treat the Gambia as though it were a child, incapable of making decisions for itself, but only under the influence of a parent international organization. It is entirely irrelevant that the OIC offered support to the Gambia in its decision to bring this case. What matters is that the decision to bring it was the Gambia's own, regardless of who recommended it. The Gambia was not pressured, coerced, or induced into bringing a case in which it had no interest of its own as a mere stand-in for another entity. The evidence is all to the contrary. It was the Gambia that first introduced the idea to the OIC that the Rohingya were victims of genocide, that they had to be protected from destruction as a group, and that Myanmar had to be held to its treaty obligations under the Genocide Convention. This is what led the OIC to name the Gambia as chair of its ad hoc committee on the Rohingya. It was the stench of genocide, not the OIC, that motivated the Gambia to come to this court in circumstances eloquently explained by the former agent at the provisional measures phase. Is it so hard to believe that the Gambia could care so deeply about the destruction of the Rohingya that it would take up their cause as its own? Madam President, it is telling and deeply disturbing that Myanmar spent 4.5 hours addressing the court in these hearings, but was unable to speak the word Rohingya, not even once. As we pointed out last Wednesday, for Myanmar, they simply do not exist and should not exist. Even their counsel, it seems, have been banned from using the word. A word that Myanmar's counsel do use with great enthusiasm is proxy, as an epithet that they apply to the Gambia. But what exactly is it that makes the Gambia, or any sovereign state, a proxy for another entity? Myanmar offers no standards for distinguishing when a state acts for itself and when it offers itself as a vehicle for another entity solely to pursue the other entity's objectives rather than its own. As my colleague Mr. Lowenstein pointed out on Wednesday, Myanmar offers no precedent for such an approach. Not a single international court or tribunal has ever held that an applicant state could not pursue its claims because it was a mere proxy for someone else. Neither the facts nor the law justify such a departure from precedent, such an affront to state sovereignty, or such an insult to the Gambia. Madam President, Myanmar's second preliminary objection is no more plausible. Friday's presentation was largely a restatement of what was offered last Monday. It did not improve upon repetition. It may have been louder on Friday than it was the first time around, but the increase in volume did not make it any more attractive. In fact, its obvious defects were even more apparent. Counsel's continued invocation of the Articles on State Responsibility is entirely misplaced and misconceived. This is a case that arises from a treaty obligation under the Genocide Convention, not one whose cause of action engages state responsibility under general international law. The issue of standing under the convention is based on the convention itself, not the customary law rules on state responsibility. As the court made clear in 1997 in the Gapchikogo-Nagimaros case, quote, those two branches of international law obviously have a scope that is distinct. This makes it even more evident that those rules are of no help to Myanmar here. As Professor Dargent pointed out last Wednesday, both Article 44A of the commentary and both Article 44A and the commentary on the ILC articles make clear by their express terms that nationality of claims is not a rule to be applied in all instances, but to be invoked only in circumstances where it is considered applicable. This, of course, begs the question rather than answers it. Whether it is applicable in a treaty case like this one necessarily depends on the treaty, here, the Genocide Convention. This is a convention that the court has already described as imposing erga omnes partes obligations on all state parties, and in which the interests of those parties are not individual or particular, but common. So the question here is whether under such a convention, an applicant state must demonstrate that it has an individual or particular interest in the form of injury to its own nationals in order to have standing under Article 9. That question answers itself. Where the obligations are erga omnes partes and the interests of the parties are common rather than individual, then each party necessarily has standing to enforce its provisions regardless of whose nationals are injured, because each of them has a right under the treaty to see that its obligations are respected by the other parties in relation to all protected groups. And this is critical. The obligation under Article 2 of the Convention is to refrain from acts of genocide which reflect, quote, an intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. The obligation is expressly in relation to a group and is not limited to a group comprised of nationals of another party. According to Myanmar's interpretation of the convention, a state party may intentionally set out to destroy all of its Muslims, or Christians, or Hindus, or Asians, or Africans, or ethnic Germans, or Japanese. And as long as those it targets are its own nationals, no other party to the convention, not even Germany or Japan, can come to this court under Article 9 to hold it to account for this most blatant breach of its treaty obligations in order to bring the genocidal conduct to an end. Myanmar's interpretation is not only wrong, it is dangerous. As Professor Sands said last Wednesday, if this were accepted and the court were precluded from hearing a case where the applicant state is not complaining about genocide against its own nationals, the convention would become a dead letter. By making this argument, Myanmar not only seeks to escape judgment in this case, but to decapitate the convention itself. And it invites the court to wield the executioner's axe. Madam President, Hannah Arendt did not participate in the drafting of the Genocide Convention, but she eloquently captured part of its object and purpose in her 1951 classic on the origins of totalitarianism. Quote, "The right of every individual to belong to humanity should be guaranteed by humanity itself." The convention was drafted so that the rights of groups, ethnic, racial, religious, and national, to belong to humanity, to avoid destruction at the hands of a state, would be guaranteed by humanity itself, as represented by every other state party to the convention, regardless of whether their own nationals were the targets of destruction. This was indeed the tenor of the court's order on provisional measures, in which it said, quote, "There is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on states parties thereto, and the right of any state party to seek compliance therewith by another state party." The Gambia, as a state party to the convention, indisputably has, as the court put it, quote, a legal right or interest regarding the subject matter. Even Myanmar concedes this. As the court observed in its provisional measures order, quote, Myanmar accepts that because of the Erga Omnes Party's character of some obligations under the convention, the Gambia has an interest in Myanmar's compliance with such obligations. Myanmar acknowledged on Friday that the court, quote, uses the terms standing and legal interest interchangeably. Well, this leads to only one conclusion. Because it has a legal interest in Myanmar's compliance with its obligations under the convention, the Gambia necessarily has standing to bring its claims. Myanmar contends that its argument to the contrary is supported by the travaux préparatoires. But its counsel avoided recitation of anything from the travaux. There was a very good reason for this. The travaux tell a completely different story, that the intention of the parties was not to limit its protections to nationals of third states, but quite the opposite, to prevent a state from committing acts of genocide against its own nationals. Here are just two examples. According to the representative of Greece, Mr. Spiropoulos, genocide could be committed against the nationals of the state itself or against aliens. If a state ordered the destruction of a minority group which included aliens, the convention was superfluous because the principles of international law would in any case have been violated. The nationals of the state itself needed protection, not the aliens. The representative of the United States, Mr. Maktos, expressed the same view. The importance of the new convention lies in the fact that it established a new legal relationship between individuals and their governments, which, when the convention would come into force, would no longer be able to deal with their nationals as they pleased, but would be answerable for their actions under international law. On Friday, we heard the extraordinary argument, said to be drawn from the Nuremberg proceedings, that the 1948 convention, which followed, is not aimed at holding states accountable, but only at, quote, individual criminal responsibility for acts of genocide. Really? That proposition cannot be squared with the text of Article 9 itself, which refers to, quote, the responsibility of a state for genocide or for any of the other acts enumerated in Article 3. After the court's judgment on the merits in the Bosnia case, Myanmar's claim is even more hopeless. The nationality of claims simply has no role to play when assessing standing under the Genocide Convention. Madam President, for the sake of completeness concerning Myanmar's second preliminary objection, I will address one final point. Last Monday, counsel for Myanmar questioned the standing of the Gambia to request that Myanmar make reparation to the victims of its genocidal acts. That argument, sensibly, was not pursued on Friday. In any event, it has no merit and can only arise, if at all, when the issue of liability for a violation of the 1948 Convention comes into play. It is not an issue that may be said to possess an exclusively preliminary character. Madam President, Myanmar did nothing on Friday to improve its case on the third preliminary objection either. We have three comments on counsel's argument. First, Professor Kolb reaffirmed what he wrote in the 2009 OUP commentary on the Genocide Convention. Since this is now a matter of agreement between the parties, we will display it again. Article 9 allows a unilateral seizing of the ICJ by any party to a dispute. Moreover, it must be noticed that the compromissory clause in Article 9 of the Genocide Convention contains no further limitations, for example, as to previous negotiations. Such restrictive conditions may prompt delicate problems, all of which are avoided in the Genocide Convention. Article 9 of the Convention is in this respect a model of clarity and simplicity, opening the seizing of the court as largely as possible. To this, we simply add QED, quod erat demonstrandum. Professor Kolb apparently feels less of a sense of ownership over what he said about the travaux préparatoires in relation to Articles 8 and 9. And this is our second comment. On Monday, he told the court that the travaux, quote, confirm that Article 8 covers all principal UN organs, including the court. This statement was thoroughly refuted by my colleague, Ms. Pesipanoja, on Wednesday, who showed you in some detail that the travaux fully demonstrated that Article 8 was expressly intended to apply only to the political organs of the United Nations and not to the court, whose jurisdiction and season were governed exclusively by Article 9. Just as Professor Kolb wrote in his treatise, and just as the court concluded in its provisional measures order. What was Professor Kolb's response to Ms. Pesipanoja on Friday? Well, the travaux are just an ancillary source. This is an old but seldom successful legal strategy. When your argument is exposed as fallacious, abandon it and claim it doesn't matter. Our third comment relates to the one new argument that Professor Kolb made in the second round. A bold claim that is, in his words, quote, what I would like you to bear in mind above all from my two speeches to you. And what was this? That the court must not concern itself with the, quote, objectively correct, that's a quote, interpretation of Article 8, but instead it must ensure that it gives effet utile to Myanmar's reservation to Article 8. Here, he treats the text of Article 8 the same way as its travaux. He tells the court it doesn't matter what the article says or what the drafters of the article intended. The only thing that matters is what Myanmar intended by its reservation. Madam President, this is a remarkable argument to be made by a professor of international law, that the proper interpretation of Article 8 and whether the court is included within its scope depends on how Burma understood the article at the time it made its reservation. We had to reread the Compte Rendu several times to make sure that this was what Professor Kolb actually said. And it was. He really did argue that if Burma intended to remove itself from accountability to the court, as well as the political organs of the UN, by means of its reservation to Article 8, then this understanding must prevail, with the consequence that no state party may seize the court with any claim against Myanmar under Article 9. For Professor Kolb, what matters is the reserving state's understanding of the article to which it is making a reservation, rather than the meaning of that article itself based on an ordinary reading of its text in light of its object and purpose. As a matter of law, such an argument, to be polite, is dubious. But it is also, in the circumstances presented here, entirely unsupported by the facts. There is absolutely no evidence that Burma contemporaneously understood itself to be including the court in its reservation to Article 8. The only contemporaneous statement by Burma on its reservations to Article 7 and Article 8 makes no mention of the court. Instead, as pointed out by Ms. Pasipanoja, the contemporaneous statement records Burma's express support for, quote, all the other articles to which it did not enter reservations, which of course includes Article 9. Very conspicuously, Professor Kolb was completely silent about this. Instead, he repeatedly implored the court to ensure that Myanmar's reservation to Article 8 must not be without effet utile. However, as Ms. Pasipanoja showed you last Wednesday, and as more fully laid out in the Gambia's written submissions, the reservation has an effect without Professor Kolb's unsustainable interpretation. Burma's reservation to Article 8 limits the ability of the Security Council and other UN political organs to interfere with the exercise of its domestic jurisdiction in relation to acts prohibited by the Convention. In addition, Burma's reservation to Article 8 was intended at the time to prevent those states who were members of the Convention but not members of the United Nations from being able to call upon competent UN organs to address acts of genocide related to Burma, even in the absence of their UN membership. The court's rejection of Myanmar's second preliminary objection would not in any way deprive the reservation of these effects. On Friday, Professor Kolb completely ignored both our oral and written submissions on these points. His argument on effet utile is groundless, both on the law and the facts. Turning to Myanmar's fourth preliminary objection, we heard absolutely nothing new on Friday. There is very little else to say today. Can it seriously be